Let's move on to our next issue, and we are dealing with what happened on the 6th of April 2017, where 13 members of the Delta Force group who were standing trial at the Circuit Court in Kumasi for offenses of assault of public officer, causing unlawful damage and rioting or resisting arrest, is it? They were sort of rescued somewhat by 8 other members, allegedly. In fact, there are supposed to be 9 other members. According to police, 1 person is on the run. The person is on the run is by name Marcus. And this is the police that is unable to identify even those that they have brought before the court. And yet they are clearly aware that one is on the run, and that person's name is Marcus. We'll ask all of those questions right here. Now, I think that it will be good to start with Roxing on this note. I'm sure that you're waking up yesterday when Assange was getting his liberty. They said, the Swedish prosecutor said, we are no longer going to prosecute. It was sort of a similar situation.
Indeed.
We are no longer going to prosecute. Indeed. And he says, no, you have leveled rape charges against me and all of that, and I have been holed up since 2012 in this small embassy without sunshine and all of that, and you just show up today and you say all is over, it's okay. No, he doesn't agree with them. The public opinion appears to be overwhelming against what the Republic is trying to convince them, that nothing went wrong in this matter. And you have come in as a minority, and you say they ought to be rearrested and the process ought to start all over again. Why do you say that?
Now, the doctrine of nolle prosequi is a common law doctrine that eventually found its way into our statute books. And of course, Kwaku being a lay person is as much abreast with this matters. Oh, no. That's what I'm clarifying.
You're saying it within a context.
Yeah, sure. That Kwaku being a lay person amounts us here is as much abreast with the legalities as you and I. And so I won't belabor that point. Now, the question in this matter is this. It is not the truncation that the minority finds offensive, but it is the manner in which it was done. Because this is the constitutionally legitimate power to exercise. So we do not fault the office of the Attorney General. And we are not saying that it is the Attorney General, Attorney General, who exercises this
Even
power.
before you proceed, Joseph, is it a nolle prosequi that was entered?
I just wanted to put that on record.
No.
You see,
let's move on from there. I want that correction.
Let me make the point. Let me make the point.
Just wait. Is it a nolle prosequi that was entered?
No nolle prosequi has been entered in this matter.
Okay, so what has happened?
It is total falsehood to say that nolle prosequi was entered in this matter.
Okay.
It was an application to withdraw the matter based on advice proffered by a state attorney.
Okay.
There's no nolle prosequi. And you see, we have to stick to the facts. I have read over and again, and I know it's not my turn to make a contribution on this matter, but I've read over and again submissions allegedly coming from the minority in which they claim that a nolle prosequi was entered. No nolle prosequi was entered.
Okay.
In this
so
matter.
now you can continue, but I'll return to you to ask whether the effect is any different.
Sam, you see, this is law. The matter in issue is purely law or purely legal. And so the education must be succinct. When you enter a nolle prosequi, technically it ought to have come in a form of a letter or an instruction from the office of the Attorney General. Now, if you take this and juxtapose it with the matter in issue, the legal opinion, which is technically called the fiat from the senior state attorney in issue, was directing the police prosecutor in the matter to, as it were, discontinue with the matter. Now, when you enter a nolle prosequi, you are saying that you no longer has an interest in them to pursue the case. And I'll read the relevant sections from our criminal procedure code. If you go to section 54, subsection 1, in a criminal case, and at any stage of a criminal case before verdict or judgment, and in the case of preliminary proceedings before the district court, whether the accused has or has not been committed for trial, the Attorney General may enter a nolle prosequi by stating in court or by informing the court in writing that the Republic does not intend to continue the proceedings. Okay. 2. Where the Attorney General enters a nolle prosequi under subsection 1, the accused shall be discharged immediately in respect of the charge for which the nolle prosequi is entered. Or the accused shall be released where the accused has been committed to prison. Or C, the recognizance of the accused shall be discharged where the accused is on bail. Now 5.3 says, 54.3, the discharge of the accused shall not operate as a bar to subsequent proceedings against the accused in respect of the same case. Okay. Now, there's a section in this same procedure code.
59.
Yes, that says that if you dictate from the charge sheet that the appropriate charges perhaps must not have been preferred, and or you intend to make an amendment to the charge sheet,
read it, because what you're saying may not be found there. Okay. Section 59.
Yes.
Because that's what they say. They are saying that what they have used is Section 59.
Yes.
But you seem to want to contest that it is Section 54 instead. Okay. I don't know how that works. They are the ones who did their thing.
I agree.
And they say they did a withdrawal.
I agree.
And you want to insist
we are
that
dealing with the facts as is on the ground.
Yes, Act 30.
Now,
yes.
Now, Section 59(1). In any trial or preliminary proceedings before a district court, a prosecutor, with the consent of the court or on the instructions of the Attorney General, at any time before judgment is pronounced or order of committal is made, may withdraw from the prosecution of a person generally or in respect of any one or more offenses with which that person is charged. 59(2). On the withdrawal under subsection 1, if it is made in the course of an inquiry under Part 4, the accused shall be discharged in respect of the offense or offenses. Or B, if it is made in the course of a trial before the case of the prosecution has been closed, the accused shall be charged in respect of the offense or offenses. 52(bii). After the case for the prosecution has been closed, the accused shall be acquitted in respect of the offense or offenses.
Okay.
Now,
let me give you this information before you go on.
Yes.
You see, this is strictly for the district court. Now, the authority to anchor you, because this happened in the circuit court.
That's right.
You can find that in 54(5).
Of Act 30.
Act 30. 54(5) says that the provisions there apply mutatis mutandis to the circuit and high court.
That's correct.
So you have to read that so that you can clothe the circuit court as having jurisdiction to have done what they did.
To do what they have done.
Absolutely.
Now, this is our argument that if you intend to amend, alter, vary a charge sheet, this is not the manner that you do it. It is done almost immediately. And you and I have been defense lawyers as well as you in many criminal matters. They do it in situ the court. It is done immediately. The accused steps down from the docket and then remounts the docket, and the new charge sheet is read. His plea is taken on the new charge sheet, and then the matter proceeds. Now, but the question is this: but for the fact that this issue, this scandalous matter, shocked the conscience of the Republic, and issues are being raised. Is the prosecution saying that they had every intention to go back to this matter? And at what point are they going to reinvestigate the matter? Even though the doctrine is that there's no time bar to investigating a crime. So we are saying it was a clever attempt to file a nolle prosequi in the matter. Because you see, the effect is this. The persons have been discharged. And when you file a nolle prosequi, the law is very, very clear. The people will walk. So now, what is interesting is the reaction. And it is never the convention that where a chief state attorney, who is ordinary resident and manning the office in a region, under whom there are several principal state attorneys and senior state attorneys, when they do things like this, they must have recourse to the center in Accra. But internally, when sensitive matters of this nature occur, the appropriate thing to do is to instruct that the prosecution be conducted in the center, and that is in Accra, so that the AGs of the AG's office will have a close monitoring and control of proceedings. And I'm sure that if this were to happen in Accra, we wouldn't have been in this mess. So for anybody to say that they move under 59 and not under 54 in this matter is just a legal gymnastics.
I don't get your point.
Yes.
What is the effect?
The effect.
That's
yes.
In both cases.
Yes.
In both cases,
yes.
For as long as the prosecution has not closed its case in the matter, particularly for withdrawal, there's no acquittal. There's going to be a discharge. And once you have been discharged, it does not mean that you cannot be rearrested. You can be rearrested and the case can start afresh.
Yes.
So if in both cases, whether you're using nolle prosequi or withdrawal, this is the effect, what is your argument? I don't get it.
You see, the argument is a fine one, and this is this. They are saying that they exercise this because the evidence as contained in the docket in question is no evidence. Because they are not saying on grounds of insufficiency of the evidence to meet the minimum burden of proof, which is proof beyond reasonable doubt. But they are saying that the evidence as brought to her by the prosecution amounts to no evidence at all. So they use the expression for lack of evidence.
Let's read her.
Yes.
In a part of this advice that was given, it eventually says that, and I'll read just about 3 of the paragraphs, says, all the suspects have also denied in their statements that they committed any offense. In fact, none of them admitted they entered the courtroom that day, though some of them admitted being outside the courtroom that day. It is a basic principle in criminal prosecution that there can be no better identification of an accused than the evidence of a witness who swears to have seen the accused committing the offense. As it stands now, there was not even a single witness who can aid the prosecution to identify any of the suspects. There is also no other piece of evidence that links any of the suspects to the offense they have been charged with. Despite the unfortunate and despicable incident that occurred, the manner in which it occurred, the investigations conducted, and the evidence available makes it extremely impossible to successfully prosecute any of the suspects herein. I therefore advise that the charge of disturbance of court and resisting arrest and rescue against the suspects must be dropped for lack of evidence to prosecute.
Good. The evidence that she's evaluating, was it an evidence on oath? Evidence led on oath? So she's using a right legal principle to apply to a set of factual situation, and which inevitably will lead her to a wrong conclusion. Because the evidence we are assessing is not one that has been delivered on oath. Yours is to evaluate the evidence and see that can I effectively prosecute this matter? And prosecution, there should be no presumption that when you are prosecuting, you must necessarily achieve conviction. No. Yours is to prosecute the matter.
No.
Why? Hold on.
No.
Yours is to prosecute the matter. It is the right of the defense in this matter to punch holes in the evidence that you prefer. When they succeed, then it is up to the court to determine whether or not, based on the evidence that prosecution led, the cross-examination conducted by the defense, and the evidence that was also led by the accused persons in this matter, the probative value that the court will place on it, whether you must achieve conviction in the matter.
In the nutshell,
yes,
the minority is of the view that there is evidence to prosecute these 8.
We are saying,
and therefore they ought to be rearrested.
Yes, we are saying that there are other reasonable sources of soliciting or eliciting for evidence in this matter. The trial judge, who was sitting in a composite capacity that day, is a material witness in this case. Has a statement been taken from her? The court clerks who were in court calling the cases before the pandemonium broke out, they are a material witness in this matter. Did prosecution take statements from them? Court bailiffs who were in court before this matter occurred, did prosecution take?
It's not guaranteed that court bailiffs would have been present in the court.
You don't know. We are giving.
No, but you are suggesting that they would have been present.
All these court personnel will be in court.
No, bailiffs.
Listen, yes, bailiffs, they could be in court. Why not?
They could, but you didn't say could.
Yes.
Okay, go ahead.
You understand? And we are saying even the journalists who came to court that day to cover the event are also material. Did prosecution make the effort to speak and take statements from any of these? We are saying that the possible angles from which to solicit for concrete evidence in order to effectively prosecute this matter have been ignored or not exhausted. So, as a senior state attorney who was reviewing this brief, her duty was to give further directions that, please, look at these other angles and come back.
Okay.
But to base it on this.
Okay, thank you. Let's hear from Joseph. What you say, and I don't want us to dwell too much on the technicality of whether it's a nolle prosequi or it's a withdrawal. For as long as those of you who did the job, went to court to do the job, said this is a withdrawal, that's what it is. It's a withdrawal. So let's move on. It's a withdrawal. But then now the public opinion heavily is that this was a joke of sorts, that you just needed to make a political decision in this matter to let these guys off the hook. How do you explain that?
That's incredible. You see, I listened carefully to my brother, trying very hard to import things that do not exist at all in this matter. And we have to situate whatever happened within a certain context.
I never imported.
Very well.
Make your point.
To situate this within a certain context. And I'm happy you're saying that we should not try to do the differentiation between a nolle prosequi and a withdrawal. But for me to be able to connect the issues well, let me just a little bit. You see, when I read the statement from the minority, with the greatest respect to the reader, I thought that some mischief was intended.
At all.
You see, when you enter a nolle prosequi, there could be overwhelming evidence to secure conviction, yet you enter nolle prosequi.
Yes.
It's a prerogative.
It's a prerogative that is exercised by the AG. But in this particular matter, the conclusion was that there was no evidence and that the charges against them be withdrawn. That was the application.
There is an
So
alternative.
I want to state to my brother that they should swallow a humble pie, that there was no nolle prosequi entered in this matter. No nolle prosequi was entered by any person in respect of the present matter we are discussing. And we should situate that within a context. It was a withdrawal. Now, what occasioned the withdrawal? You see, we must be able to give some amount of respect and independence to our professionals to function. Otherwise, what we are going to do is that we are going to act contrary to the dictates and principles of our Constitution, which is that we should be fair to all manner of persons. We should not discriminate. Now, there are hundreds of thousands of matters pending in our various courts in Ghana. And this is one of them. Public outcry and all that. Fine and good. Most important thing is this. At the time the information was available to this senior state attorney to advise on the matter, what was it? The investigator had taken evidence from 2 police persons who were in court at the time the incident occurred.
Right.
Now, those 2 pieces of evidence before the state attorney, one of them stated that he could not identify the persons who acted. The other also confirmed same. Now, you know that there are a plethora of legal authorities that say that in mob actions, unless you are able to identify individual responsibility, maybe the only one you can go for will be rioting. In specific cases like that, if you go and read Cambe in the Republic, and this is a technical matter, you will see it, which was in respect of murder. They acted spontaneously. And I reckon that what actually happened on the said day was a spontaneous action. And so persons who were available there, it would be difficult for you to stand there and be looking at people's faces to be able to identify them. But be that as it may, these 2 police persons who were supposed to be principal witnesses for the state in the successful prosecution of the matter have stated without equivocation in their statement to the police that they could not identify the actors. Now, what my brother is saying would have been the most dangerous leg for the Republic to take. Namely, that put them into court and let the court take a decision and the defense raise loopholes and the court take a decision. That one would lead to acquittal.
His main point, though, is that there are alternative sources of validating the information that you have, which is the truth. The truth being that the court's process was disrupted on the day. But to get the evidence to back it and to identify the individuals was the one in issue. So he's pointing to you, court officials in court on that day, lawyers, others who were attending court on that day. Can they help?
Something. You see, that's why I'm just moving towards a certain direction. I'll answer those ones. That's my last bet on this matter. You see, so what I was just talking about was that at the time, the evidence had been taken from these persons. And I'm saying that we are looking at the advice that was proffered by the senior state attorney leading to the withdrawal of the matter. Now, you build your case in court based on the docket. And I have credibility to protect, and I know the senior state has credibility to protect. You don't go to court when you know obviously that you are going to lose. I will not go to court to embarrass myself. If I weigh the matter and I know that when I go I will lose, it means that it is in favor of the accused.
Doctors are not doing
We don't persecute, we prosecute. So the information that was brought before the senior state attorney, the question all of us should be answering is this. Was it sufficient for her advice to have been otherwise? If you are able to pass concrete judgment on this and you come to a conclusion that your opinion would have been different from hers, that's a different thing.
The minority is asking you that if the information or evidence supplied was not sufficient, as you suggest, what ought to have been her conclusion?
You could ask for further investigations. You could ask for further investigations. Another option is you say that for now, the evidence available cannot proceed to successfully prosecute this matter. So withdraw. But again, and that is why in all these things, I listened carefully to your intro. It's not a bar to further prosecution. If any evidence is available, including that which the minority may have, we should furnish it to the appropriate security agencies.
They speak about the video.
Yes. Have you watched that video?
Yes, I have.
That roadside thing.
Okay, just hold on.
Did you see?
Just hold on.
Let's
Let's play that video on that day and see what exactly was captured on that video.
Hey,
All right, so you have seen the video.
I've seen it, and this is what I'm talking about.
There's absolutely nothing. It's so worthless.
That's
in your estimation.
You see, you are talking about rescue.
This video.
You are talking about rescue, the charges and all that.
Disturbance
of court. What you see is not within or inside the court. It is outside. You will not know what triggered that and all that. So you just go and play this video and tell somebody that because these people are outside making a hell of noise, convict them. If that is enough evidence to proceed, so be it. But the point I am making is this, that these pieces of evidence we are talking about, with all intent and purposes, you have to weigh the probative value and find out whether or not this is persuasive enough in a criminal trial of a charge of rescue, which must have happened within the precincts of the court. And I have said it time and again, that even with this particular piece of information that we have, which is namely the tape, we will not get anywhere if we are going to proceed strictly based on this one. We will not get anywhere. But, Samson, there is something I want to conclude.
It's not even useful if you are able to pick out those guys we saw, you know, insulting the judge in a language that's obviously very terrible. It's not even useful if you pick those guys. There's nothing you can do with them.
There is. You see, what I'm talking about, you see, is in respect of the charges before the attorney. The charges, we should speak to the charges. Otherwise, you will just go arresting people. You have to speak to the charges that were preferred. And I'm saying that based on the charges that were preferred, you cannot secure a conviction with this tape. Again, that piece of evidence was not even part of what the state attorney used in arriving at the conclusion. But you see,
does it surprise you that that is not part of the evidence? Something that is all over on social media everywhere. Does it surprise you that it's not part of the evidence?
You see,
it's not on the docket.
Samson, there was an investigator on this particular matter.
Right.
The investigator builds a docket and forwards the duplicate docket to the Attorney General's Department for professional advice. The docket that was built was with a certain piece of information. And that is why we have said that we are not, look, the Attorney General's Department, we are stating this on record, that we are prepared to do a meticulous job on this matter, provided people provide us with sufficient evidence that will secure a conviction when we go to court. Okay. That's why we have said time and again. But again, in response to certain issues my brother raised, all that happened in this matter, first, ask this fundamental question. The senior state who proffered the advice, had he the right to do that? She had the right under Article 88, 3 and 4 to do what she did. Because she has the mandate of the Attorney General to do that. Did she pass professional judgment on the matter? And these are the things that happen every day in the regions. Because otherwise, all the thousands of cases across the country will be brought to Accra. And the Attorney General will be inundated with so many things that she can't do anything about. That's the practice. The regions have the right to proffer advice based on facts before them. So she did those things professionally and based on, again, the facts before her. And I'm challenging the minority to tell me what would have been, whether their decision would have been different if they are provided with those set of pieces of evidence. And I'm saying
their decision would have been different, and that their conclusion, if they were the state attorney or the senior state attorney, would have been that go back and get your work, do further investigation. You hold it there. We take a quick break. When we return, there are a number of questions that we'll have to answer, including whether or not even those we find in the video, even they were charged with disturbance of the court. Now, you are saying that if that video is available, you can pick some of those people who were clearly seen insulting and misbehaving to constitute disturbing the court. That can also be contempt in itself. But are those the people who were arrested and put before the court? Because the question is identifying them. We'll be right back.